Good day, and welcome to Epstein Becker Green and EBG Advisors webinar series, The Effect of the Average Manufacturer Price Final Rule on Drug Pricing and Contracting. Today's session is Part 1, The Impact of the AMP Final Rule, Legal, Operational, and Financial Considerations. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You are welcome to submit questions throughout the program by using the Q&A feature provided by WebEx, and at the end of the program, with time permitting, the speaker will address your questions. You are also welcome to submit questions directly to the presenter following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have a fantastic speaker today. Epstein Becker Green's Constance A. Wilkinson is a member of the firm in the litigation and healthcare and life sciences practices in the firm's Washington, D.C. office. At this time, I'd like to turn the webinar over to Constance Wilkinson.
So this is Connie. As we go through, what we're going to try to do today is provide a little bit of background on the final rule, how we got to where we are today and where we are today, and then to do a little bit of discussion of kind of the broad landscape of what the rule did, and then drill down on some specific topics, some of which I think will be helpful then to the discussion tomorrow about value-based pricing. So that's the goal of the presentation today. The AMP final rule was published in February of this year. It's under the Medicaid program and addressing covered outpatient drugs specifically. And it implements revisions to the Affordable Care Act. And if you look at the timeline at the bottom of your screen, you can see the Affordable Care Act was passed in March of 2010. It was 2 years after that before we got the proposed rule on covered outpatient drugs and these particular provisions. So that was February 2012. And then it's 4 more years to this February before we get the final rule. So you can see that a number of these provisions have been in the law for a significant period of time already, but it was only recently that the regulations were finalized. So many of these provisions are already in effect. Most of the provisions under the rule were effective as of April 1st. So for the price reports that manufacturers were submitting at the end of May, the implementation for the Fide drugs, which we'll talk about in some more detail, was delayed until July 1st. So the price reports that go in at the end of this month, or I guess at the end of next month, will reflect those changes. And then one provision that is delayed until next year, till April 1st of 2017, is the expansion of the Medicaid Drug Rebate Program to Puerto Rico and the U.S. territories. And then the states have until the end of that quarter to file their state plans reflecting their changes in response to this rule. So that's an overview of the effective dates of the program changes. Now, on to the scope of the final rule. There are a couple of key areas that the final rule addresses, and one of those is the definitions and terms under the program, and one of the greatest changes is the definition that it incorporates a definition for average manufacturer price, which was not included in the regulations prior to this time. One of the other notable changes is the implementation through the regulations, which was attempted before but then sort of stalled by litigation, that ties the reimbursement to the retail pharmacies by the state Medicaid program to the AMP price metric. And so for multiple source drugs, it establishes the federal upper limit based on the AMP. And this requirement for establishing the federal upper limit is triggered when there are 3 drugs that are therapeutically equivalent, A-rated, innovator or non-innovator, at the NDC-9 level. And so when that's true, an FUL will be established that's not less than 175% of the weighted average monthly AMPs for the drugs that are included in that full. Another change that's made for other drugs, for single source or multi-source drugs for which there are not, the full requirement is not triggered, modifies the standard for reimbursement from the historical standard of estimated acquisition cost, which was interpreted variably by the states in their definitions of that, to actual acquisition cost. And you can see under this development that there is an attempt to more closely align the drug reimbursement or the reimbursement for the drug ingredient cost to something that truly reflects or more closely reflects the drug pricing. A sort of companion development is that there is an establishment under the program of a professional dispensing fee, which is meant to be the compensation to the pharmacist for the services they provide, including the dispensing, patient eligibility verification, patient education, those types of activities. And so again, you can see that instead of the pharmacist receiving compensation through a sort of excess reimbursement for the drug above the drug ingredient cost, there's an attempt to true up in a closer way the drug cost, and then to recognize that there should be a service fee or a professional fee that's adequate compensation for the pharmacists for their services. So the calculation of the Medicaid Drug Rebate Program rebate is important to understand if the terms and the issues that we discussed today are going to make sense. So I'm going to start with a little background on what the requirements are under the program. If a drug manufacturer wants their drugs to be covered under the Medicaid Drug Rebate Program, they enter into a national rebate agreement with CMS under which they agree to pay a rebate on each unit of its covered outpatient drugs, and that's a defined term, that are reimbursed by the state Medicaid program. And one of the requirements under the program is that the manufacturer has to submit certain pricing metrics on a monthly and quarterly basis. And so the AMP is submitted by a manufacturer each month and quarterly. Best price is submitted quarterly. And then customary prompt payments and nominally priced sales are also reported, but those don't factor into the rebate calculation specifically. And then CMS takes those pricing metrics and it calculates the unit rebate amount for the drug. So for non-innovator multiple source drugs, the unit rebate amount is set at 13% of AMP. And that's the end of the story for now. For single source, innovator, multi-source drugs, there are potentially 2 components to the rebate. There's the basic rebate, which will be based on either a percentage of AMP, 23.1% of AMP in most cases, or 17.1% for clotting factor or a drug with an indication that's exclusively for pediatric use, or AMP minus best price if that would result in a greater rebate. And then for many drugs, there is an additional rebate, which is really akin to an inflation penalty that's equal to the difference between the current quarter AMP and the base date AMP from way back when the product was launched. The base date AMP is the AMP from the first full quarter in which the product was marketed. And that calculus will include an adjustment for inflation. But because of this, many drugs are subject to a very large additional rebate because of their longevity. So those are the elements to the calculation of the unit rebate amount. And as you can see, the two key considerations are the AMP and the best price. So, and while the rule focused primarily on AMP, it did also make some changes to the best price methodology, in many cases to true it up more closely to the AMP inclusions and exclusions. So we'll talk a little bit of that as we walk through. Moving on to financial impact, most of the impact of the changes that were made by the Affordable Care Act and the AMP final rule increased manufacturers' rebate liability. And that happened in a number of ways. As we know, the Medicaid program itself was expanded by making many more individuals eligible for that. In addition, the Medicaid Drug Rebate Program specifically was expanded to include Puerto Rico and the U.S. territories, and this was done through a change to the definition of states and United States, which in the past had not included the territories, but was changed to include them. Another change was that the Medicaid Drug Rebate Program statute historically had excluded Medicaid managed care utilization from the program and from the rebate obligation. And the Affordable Care Act changed that to include that utilization into what was eligible for a rebate to the states from the manufacturers. In addition to that, the minimum rebate percentages increased. The 23.1% that I mentioned was an increase up from 15.1%. The 13% for the generic drugs formerly was 11%. So you can see some significant increases in the rebate percentages themselves. The Affordable Care Act articulated a particular treatment for line extensions of oral solid dosage forms of drugs. And for those line extensions, the treatment that was taken under the Affordable Care Act and now implemented through the final rule was that the base date AMP would not reset for those products. So the base date AMP would be the base date AMP for the original product of which this drug is a line extension. And because of that, the additional rebate or that inflation penalty component will be higher, which will lead to a higher URA. So that's a significant impact for manufacturers who had thought that some of these products would involve a reset. And the definition of the line extensions and some of the treatment of that is the only issue that is still open for discussion really under the rule. There was a submission of a further comment period, and we may get some additional guidance on that. And then the final thing I wanted to note that would raise the manufacturer's rebate liability is that there were additional limitations or an additional restriction to the circumstances in which a manufacturer could blend their authorized generic sales AMP with their branded product sales, and we'll talk about this in a little more detail. There were only a few changes that decreased the rebate obligations, and the primary one was a provision that caps the unit rebate amount at 100% of AMP. So if you have one of these products where the rebate obligation is really being driven by that additional rebate, there's some relief when you reach the point where the unit rebate amount would be at the 100% of AMP. So to look specifically at some of the price calculating and reporting provisions, as I mentioned, AMP is defined under the final rule. AMP is based on manufacturer sales to retail community pharmacies as opposed to prior to the ACA when it was described as the retail pharmacy class of trade. And these are manufacturer sales that are made either directly or indirectly through wholesalers. One of the very welcome positions that was taken by CMS in the final rule was its decision not to change what had been manufacturers' typical practice of presuming that the sales that were through the wholesalers were for drugs distributed to the retail community class of trade or retail community pharmacies in this case, unless they had evidence to the contrary. And CMS had proposed a different treatment. There was wholesale backlash against that because of the operational difficulties of achieving that. And in the end, CMS determined that it would allow manufacturers to continue to rely on what's typically known as presumed inclusion. And what this means is that if a manufacturer has a contracted price with an entity that results in a chargeback coming through the wholesaler system back to the manufacturer, then typically that's considered to be evidence that those sales are to, for instance, if it's a hospital, that those sales are to an entity that would not be within the retail community pharmacies. But they won't be put in the position of having to sift through every single sale to figure out who the ultimate customer is. And one of the concerns with this, and one of the sort of words of wisdom that I would give on this is that, as always under the pricing calculations, we look for consistency where there is not good justification for diverging in the practices. And the presumed inclusion approach is one of those elements of the manufacturer's methodology that should be applied consistently in the standard AMP and then as well in the alternative 5i AMP calculations that we'll talk about. So when you're making those determinations of what you will presume to be included, you want to be following the same rules for both of those AMP calculations. In terms of some of the other significant changes that were made by the final rule, we'll talk a bit more about authorized generics. There was, in fact, reinstitution of a slightly different smoothing methodology than in the past. As many of you know, if you've been working with the program for some time, as a result of the Deficit Reduction Act and the final rule that went into effect in 2007, there was a 12-month rolling average estimation methodology for lagged price concessions, in other words, price concessions that are only known after the fact. When the litigation forced the withdrawal of the changes to the AMP rule, that smoothing methodology was pulled back out of the regulations. So while CMS has given some guidance in the meantime about the use of a smoothing methodology, it's now reinstituted or reimplemented through the recent final rule. And in fact, CMS indicated that a smoothing methodology could be used in some other instances as well beyond the lagged price concessions, including the identification of AMP ineligible sales and the alternative 5I AMP threshold. So in other words, when does the 5I AMP apply as opposed to the standard AMP? So you can see that there's sort of an acceptance that that type of smoothing of data over a longer period, the standard at this point for the lagged price concessions is 12 months. That may be flexible in some other circumstances, but that making that determination based on a longer period of time, a longer base of transactions, is recognized by CMS as being appropriate in some of these cases. So I think that's a helpful, useful development. Certainly some manufacturers had been using smoothing methodologies for other components of the calculation as well. We'll talk in a little bit more detail about the multi-part test for bona fide service fees. And then the final item here was the identification and rebate calculation for the line extension products, which, as I said, may be subject to further guidance since there were further comments submitted. There's a question I'm trying to read. Can we get the bottom of that?
Sorry about that. One moment.
Okay, so the question is there a suggested percentage at which we can still presume sales are to retail community pharmacies, even if we get chargebacks from certain non-retail community pharmacies? Yeah, so my next slide will be talking about that a little bit, because that's really the question I think ties into the question of when would you flip to the 5I AMP calculation as opposed to the standard AMP calculation. And one note I would make here is that many elements of the calculation and aspects of the final rule are subject to some interpretation, because while CMS has tried to define more fully the standards, the thresholds, the treatment of particular elements of the calculation, it's not always absolutely clear what their intent is or their bottom line is. And in some cases, these are not, always bright line tests. So I'll try to address that as we go through this next slide. But the role of reasonable assumptions in manufacturers' calculations will not diminish with this final rule. So there will still be circumstances in which you need to make some further interpretations in order to operationalize this. So the 5I AMP is used for, it's an alternative AMP calculation that's used for drugs that are not generally dispensed through retail community pharmacies, and specifically CMS identified this as applicable to 5I drugs, which are drugs that are administered through inhalation, infusion, they're instilled, implanted, or injectable, and those are the 5 I's. Which drugs fall into these categories are to be determined by the manufacturer based on their understanding of how the drug is administered. So CMS is putting that onus on the manufacturer to identify which are the drugs that fall into these categories as 5I drugs. The question of what does not generally dispensed mean was originally proposed by CMS to be determined based on a 90-10 division, and then that was changed in the final rule to a 70-30 threshold. So in other words, if at least 70% of the sales are not ultimately to the retail community pharmacies, then you would use the 5I AMP instead of the standard AMP calculation. And this is determined based on units at the NDC 9 level, and it's to be evaluated monthly, but not necessarily anyway, based on the monthly sales, that it can be based on a period of time, a longer period of time, which CMS is not dictating. So they used as an example such as a 12-month period, but there's no requirement that manufacturers adopt that as the evaluation period that they will use. So if you're falling under the 5I AMP, the methodology for the calculation of AMP is the same. What's different is which sales you include. And that's really the difference. So you're excluding the sales and price concessions to government, charitable and not-for-profit pharmacies, patient benefit programs, but it's based on the sales that are going through other than the retail, or going to, I should say, other than the retail community pharmacies. What CMS did not address is the drugs that sort of fall into the gap between the 5I categories and those that go through the retail community pharmacy. So if you have a non-5I drug that's not dispensed through a retail community pharmacy, there's no clear guidance given as to how that should be addressed. So I'd like to move on to talk about a couple of specific issues. As we see the rise of the use of specialty pharmacies, the class of trade for specialty pharmacy becomes increasingly critical, whether those sales will need to be included in AMP or not. And CMS had originally proposed another sort of, neither fish nor fowl category of treating entities as if they were conducting business as retail community pharmacies or wholesalers. So in addition to the definition of retail community pharmacy and the definition of wholesalers, there was this other somewhat amorphous category of entities conducting business as one of those. They determined in the final rule not to finalize that approach. And they did that because they decided that the existing definition of retail community pharmacy was broad enough that it could include some of the specific entities that they were concerned about, which were specialty pharmacy, home health care pharmacy, and home infusion pharmacy. And they decided that if those types of entities met the definition of retail community pharmacy, then they would need to be included in AMP, but otherwise they would not. And so they would leave it to the retail community pharmacy definition to be the basis on which that determination was made. And some of the factors that they referred to specifically were whether the pharmacy dispenses medications to the general public at retail prices, that it is not primarily a mail-order pharmacy, and that it's licensed. And this may require individual consideration of particular pharmacies to determine whether they fall within the retail community pharmacy definition or not. But again, I would urge you to try to maintain some consistency in the way you make these determinations and categorize these pharmacies, especially if they involve multiple products where there aren't a clear basis for some sort of distinction in the treatment. Again, looking for consistency unless there's some difference that would justify a differential treatment. So again, I think the question then would be, you know, if we're looking at the percentage at which you can still presume the sales are to retail community pharmacies, I think many manufacturers are simply assuming that the chargebacks, when they're clearly from non-retail community pharmacy entities such as hospitals, will be taken into account in figuring out whether that percentage threshold is met. To the extent that there is no particular evidence as to where the ultimate sales are going through the wholesaler, they'll still presume that those are going to the retail community pharmacies. So that's sort of the default position, is that the assumption is that it is a retail community pharmacy sale unless there's evidence to the contrary. So moving on to authorized generics, CMS had proposed a definition which it then finalized under the final rule that describes an authorized generic as a drug that's approved under an NDA that's marketed, sold, or distributed under a different label or code, a different product code, trade name, trademark, or packaging than the brand. And under the final rule, the way it works is that the primary manufacturer, the manufacturer of the branded drug, is to include the sales to the secondary manufacturer, the authorized generic manufacturer in the AMP. When the primary manufacturer sells directly to a wholesaler, or if the secondary manufacturer is acting as a wholesaler for drugs distributed to retail community pharmacies. The problem is that CMS didn't define what it means to be engaged in wholesale distribution or acting as a wholesaler, which are some of the formulations of that language that they included in different parts of the rule. But it included a description of when a secondary manufacturer is not considered to be engaged in wholesale distribution or acting as a wholesaler, which was when it relabels or repackages the drug and sells the repackaged authorized generic to manufacturers itself. And the issue with this is that it really sort of swallows then the exception, because in most cases, the authorized generic manufacturer is repackaging or relabeling the drug, and in fact, the definition of an AG includes the sale under different packaging and different label or code than the brand. So there's certainly, I think, some lack of clarity there. as to whether there will be really many instances at all in which that the secondary manufacturer sales are getting included and blended with the brand manufacturer's sales for the AMP. And so this appears to be a significant tightening up of the circumstances in which the blending would be appropriate. Interestingly, you know, they're directing that it must be included in certain circumstances. There certainly may be room for some interpretations around that language that it's not necessarily obligatory. So moving on to best price. Best price is compared to the average manufacturer price, which is truly based on an average of many transactions. Best price is based on a single, can be a single or multiple transactions per unit of a drug. And this would be, the units of measure include capsules, tablets, grams, milliliters, transdermal patches, antihemophilic. So there's a number of different types of units, but it's per unit. And then the CMS's position is that price concessions do need to be stacked. So if a unit of drug is subject to multiple price concessions, including chargebacks and rebates, potentially discounts as well, because best price includes the prompt payment discount, then you could be in a position where you're forced to aggregate those price concessions for that particular unit to reach the best price. And best price is much broader. I should say the classes of trade that are included in best price are considered for best price. The eligible transactions are a broader subset of sales than under AMP because they are not limited to the retail community pharmacies. It's the lowest price by any entity in the U.S. with limited exceptions. And so it would include hospitals, other providers who would not be included in retail community pharmacy, as well as commercial third-party payers. You know, the government sales are excluded, as are a few other limited categories of sales, but it's much broader than the breadth of the AMP calculation. Under best price, there were some specific scenarios that were raised and addressed by under the final rule. A manufacturer it can be a best price eligible entity if it meets the definition of wholesaler. In other words, if it engages in wholesale distribution of drugs to retail community pharmacies. And one of the questions that had come up was whether sales of drug to other manufacturers for clinical trials had to be included in the best price calculation. And CMS's interpretation was that because the sales for clinical trials don't reach the retail community pharmacy, that in that case the manufacturer could not be a wholesaler because it wouldn't meet the wholesaler definition. And so that drug did not need to be taken into consideration when determining best price. And in terms of harkening back to the authorized generics discussion, under the authorized generic provisions under the final rule, manufacturers are specifically listed there as being best price eligible customers for purposes of authorized generics. So this interpretation is not useful there in terms of being able to exclude the authorized generic sales from best price. So I'm going to move on and talk about a couple more issues that are maybe more relevant in relation to some of the value-based pricing and sort of value adds to drugs that manufacturers are considering. So as a basis for some of the discussion tomorrow, I thought it would be important to go through and just remind you of some of the standards around these particular issues so you can have that in mind. So historically, if you had fee-for-service arrangements with entities that were relevant to the calculations, the payments made by the manufacturers for those service arrangements could be excluded as bona fide service fees and therefore not treated as price concessions to those customers if they met a multi-part test. And the Affordable Care Act had an express exclusion for bona fide service fees from the AMP calculation and included certain enumerated types of wholesaler fees in that definition or description, including distribution stocking fees, inventory management, product stocking allowances, and then fees associated with administrative service agreements and patient care programs, including medication compliance or patient education. The reason why this is significant is because so many of the value-based pricing arrangements are drugs that are coupled with some of these other types of services, particularly as ways of sort of achieving the outcomes that the manufacturers are basing their pricing on. These types of patient programs to try to encourage adherence are seen as critical elements of some of those programs. So there were differing interpretations of the statute and whether this meant that those types of enumerated wholesaler fees were sort of given a free pass as always being bona fide service fees, or whether there was still some obligation to apply the multi-part test to those. And the final rule does affirm the use of the multi-part test. It makes it clear that a bona fide service fee is a concept that applies not only to a fee paid to a wholesaler or a retail community pharmacy, which was one of the issues that had been presented, but that in fact it would apply to these fees paid to any customer. And the bona fide service fee test that CMS is affirming is a multi-part test, the most critical elements of which are that the fee has to represent fair market value and be paid for a bona fide itemized service that's actually performed, and the fee is not passed through to the end customer. So the point is that if it's a bona fide service fee, it should remain with the entity who is performing those services. And in the final rule, CMS did not define fair market value and has resisted doing that over the years. So fair market value is something that will need to be documented as part of a manufacturer's reasonable assumptions. And there's a cottage industry of consultants who have sprung up to determine fair market value, to determine whether fees meet the fair market value test. But there will need to be some rigor around a manufacturer's treatment, in particular of this element of the multi-part test. The services are supposed to be on behalf of the manufacturer. This can be a question sometimes with service fees to specialty pharmacy in determining whether the manufacturer is paying for services that are really core services of the specialty pharmacy that maybe are more appropriately considered to be part of their business model, or whether the manufacturer is appropriately paying for services which require additional effort or heightened patient interaction, things like that might justify differentiating those services from others that the pharmacy would be performing in any event. And the sort of ultimate question of whether the enumerated services have to be subject to the full test, you know, the CMS's intent seems to be that there are no types of fees that will, you know, will simply, based on the enumeration in the statute, be considered bona fide service fees without being subjected to the test. Whether there could be some interpretations to the contrary, I think if someone were to determine that they wanted to proceed in that direction, they would probably want to make sure that they're documenting that interpretation and you know, retaining that for the record. In terms of value-based pricing itself, the final rule really contains no specific guidance on this, although CMS did indicate that they have guidance under consideration for what they described as unique arrangements. And I think one of the reasons why they're more unique than proliferating is some of the barriers and the lack of guidance on how these can be treated. They indicated that in their the guidance that they're considering that the effect on best price would be addressed, that there's an interest in clarity for states and Medicaid programs regarding such arrangements, and that CMS recognizes the value of such arrangements, especially when they benefit patients. So again, that sort of touchstone of patient benefit as being a circumstance in which there may be some you know, some room or some flexibility for these types of arrangements. And one of the things that that may be significant is that there were some revisions made to the bundled sales definition under the final rule that may have an impact on the utility of bundling as a mechanism for these arrangements. So I wanted to address that specifically. Part of, as after the initial guidance on bundling had come out in the proposed rule that made it clear that bundle discounts needed to be allocated proportionally to the drugs that were part of the bundle. There were a number of manufacturers who were somewhat leery of continuing to offer bundled arrangements or bundled sales because of the difficulty of operationalizing those allocations and, you know, having multiple FTEs spending weeks trying to unbundle the discounts for the purposes of price calculations. And then as folks started considering some of these value-based pricing arrangements, there was, I think, a recognition that bundling might potentially be useful in that, in terms of being able to allocate price concessions over a broader subset of transactions, and in that way to mitigate somewhat the impact on each particular unit of the price concession. So what happened in the final rule, first I'll touch base with the description of or definition of bundled sales. They involve a situation where a price concession is conditioned upon another purchase or a performance requirement, either of the same drug, a different drug, or another product, or when the price concessions are greater within the bundle than they would have been outside of the bundled arrangement. And the types of performance requirements that are noted are things like achievement of market share, inclusion on a formulary, tier placement on a formulary. These are all considered to be the types of performance requirements that could implicate a bundled sale. And the change that was made in the final rule was that CMS struck some of the language that had described it as, or that had indicated that the treatment of the bundled sales would be that discounts including but not limited to discounts resulting from a contingent arrangement would be allocated proportionally to all drugs or products. CMS struck the "but not limited to" language, but by doing so, it's really introduced some lack of clarity into what exactly is to be bundled, because a bundled sale is defined in terms of there being something that's conditional or contingent. So it's not a bundle in the first place if the price or discount isn't contingent upon either another product, a level of purchase or performance requirement of some sort. But the question is then, what needs to be allocated? Is it only the contingent discount, or is it the entire discount, or is that left to the manufacturer's determination? And so whether by striking the "but not limited to," they meant to indicate that only the discounts that result from the contingent portion of the arrangement are to be allocated, or whether there was some other reasoning is unclear. So there's just a lack of clarity here that should be addressed by manufacturers, specifically if they're undertaking those types of arrangements, whether it's in connection with value-based pricing or simply as another pricing strategy. So I had included a slide on 340B drug discounts that I'll cover just briefly. One of the changes that CMS made between the proposed rule and the final rule was to clarify that best price would exclude any price charged to a 340B covered entity, not only a price that was going through the 340B program. And that is more consistent with the statutory language. There's still some question whether this would cover a situation when the covered entity to whom the 340B drug was sold was in fact not eligible, when simply it wasn't a mistaken price or a sub-ceiling price that was given voluntarily, but in fact it was a sale to an ineligible entity. So that's still a remaining issue or question. Some of these other provisions had to do with the states, that the state plan will have to describe its reimbursement methodology for 340B covered entities and contract pharmacies and Indian Health Service, tribal and urban Indian pharmacies, so these particular types of entities. And then there was a companion provision that drugs that are purchased under other federal drug discount programs will be reimbursed at that acquisition cost, that actual acquisition cost. There are a couple of other developments since that point. I'll let you go ahead and read on your own in the Medicaid Managed Care Final Rule and a recent OIG report that are really focused on the Medicaid Managed Care organizations and the issue with duplicate discount under the Medicaid Drug Rebate Program if they're using drug that's purchased at a 340B discount for a Medicaid beneficiary and not identifying that properly to the states. And many of you, I'm sure, are aware of some of the issues in that area with the fact that the mechanism that HRSA, which is the agency that administers the 340B program, the mechanism they put in place for trying to prevent a duplicate discount, it doesn't lend itself well to the managed care utilization. And so there have been some issues with it not, in fact, preventing a duplicate discount scenario. So I will end it there. We will see if we have any more questions that anyone wants to address before we close for the day. You can type in your question on the sidebar, If you would like to have anything clarified or further explained, or if there's a particular area on which you'd like to get my thoughts.
Attendees should have a Q&A feature that they see, so feel free to type in your questions there. If you prefer to follow up with Connie following the webinar, her contact information is displayed. See Wilkinson at ebglaw.com, as well as her telephone number. So I don't see any additional questions coming in at the moment.
I think the only other question we had was whether the slides would be made available after the presentation, and I'll let me address that.
Yes, and 2 to 3 business days, all of the registrants will receive a link to view and download the webinar recording and the slides. So that email will be made available with tomorrow's session as well, so you'll be able to view both. Okay.
So if there are no other questions, thank you for your participation and your attention, and please feel free to follow up if you have any additional issues you'd like to address.
Thank you for joining us today. Please feel free to join us for Part 2 of the Average Manufacturer Price Final Rules Effect on Drug Pricing and Contracting webinar series tomorrow at 3 p.m. Eastern. Tomorrow's session will cover opportunities and barriers in pharmaceutical pricing. For additional details, visit www.ebglaw.com/events. And this concludes today's webinar. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you.